Ladies and gentlemen, the Chief Justice of the Republic of the Philippines, Maria Lourdes P.A. Sereno. Good afternoon, CJ. Good afternoon, everyone. My name is Ted Te, and it is my happy duty to welcome everyone to the CJ Meets the Press 2016. Today, August 25, marks the exact date, 4 years ago, when Maria Lourdes P.A. Sereno was appointed by President Benigno S. Aquino III to be the country's 24th Chief Justice and the first woman to head the judiciary. Our gathering today is made more special and significant, if only for that fact alone. That we are also joined by our friends from the media and the academe makes our afternoon even more special. To start our program this afternoon, it is my honor to invite the Chief Justice of the Republic of the Philippines, Maria Lourdes P.A. Sereno, to deliver her ulat ng hudikatura.
Good afternoon, everyone. I see many familiar faces here, and I'm happy that there are more here now who have an academic and legal background. I hope that you help me bridge the communication deficiencies that may have been existing before, so that you can in turn spread the message about how the judiciary is hard at work in order to provide justice to our people. So let me start by addressing everyone's desire to rid the country of criminality. As constitutionally designed, a court receives the evidence and convicts or acquits as warranted. When applied to the problem of drugs, courts cannot prevent the entry, manufacture, sale, or use of drugs. It does not gather intelligence. It does not enforce the law, prosecute cases, or run rehabilitation programs. What it provides is justice to the state and the victims if there is enough evidence of guilt, and to the accused if there is none. It cannot address the root causes of criminality. If courts, however, discharge their functions well, they provide the balance that will keep the social fabric intact, address people's cry for justice, and thereby prevent society's descent to anarchy. How then do we provide justice in the campaign against illegal drugs and in the campaign against other forms of crime? How do we provide justice in the other areas of disputes between private parties and between private parties and government agencies? Allow me to give a snapshot of what the court has been doing since 2012. From that time, the Supreme Court has generated waves of reforms with such energy as had not been seen before. It started with two programs, the Quezon City Practice Guidelines and the Judicial Affidavit Rule. The Practice Guidelines limits the kinds of pleadings that can be filed, prohibits dilatory motions, and observes strict time frames. The guidelines have cut down the length of time the case is being tried from 734 days to 252 days in criminal cases. It has been observed, on the other hand, that the Judicial Affidavit Rule has reduced the time for presenting witnesses by about 2/3. In 2013, the Justicier, the congestion program, was launched in Quezon City and has been rolled out in 6 other cities. As of June 2016, 36% of the targeted docket has been disposed, equivalent to 15,227 cases. This year, we have deployed 569 case decongestion officers in the NCR and regions 1, 2, 3, 4, and 7, and hopefully We will reduce the dockets of courts with more than 500 cases each in those regions and produce the same dramatic results that we have produced in the first 7 cities. We have the budget to deploy 66 more case decongestion officers. We have come to the conclusion that unless our docket is cleared of backlogs, we will not be able to meet the ideal case processing time. This requires a menu of initiatives, no single solution being sufficient, especially with the surge of new case filings. So in 2013, the court launched the Electronic Courts, or e-courts, a case management system which allows the judges and court employees to monitor case incidents in real time. The public can also view the status of all the cases at kiosks found at the various halls of justice. By the end of 2016, e-courts will be fully operational in 287 trial courts, handling about 30% of the total cases nationwide. By the end of 2019, we hope to have e-courts operational in 619 courts that account for 46.5% of all cases nationwide. It must be emphasized that our courts in Tacloban City, except the MTCCs, which are located in a separate hall of justice, are already e-courts. Together with the court's 5-year Enterprise Information Systems Plan, or EISP, the e-courts of the future will be running smart apps where cases can be filed online, case information and digitized documents are accessible online, orders and judgments are semi-automatically produced using judicial templates that judges can download, and parties are automatically notified by text or email as soon as a hearing is set by the judge and recorded in the apps. An offshoot of the e-court is the automated hearing system, a game-changing initiative previously deemed impossible in the Philippines. Here, every activity is captured in real time, enabling the court to serve the counsel the written copy of the order of the judge in as little as 15 minutes after the court issues the order in open court. Today, there are 150 courts in 8 cities that are conducting automated hearing. The key results of all these initiatives is doing more in less time at less cost. For litigants, for lawyers, for media, because you can already make updated reports, for the judiciary, for the prosecution service, for public attorneys, and for the rest of government who have cases before us. Then we proceeded to refine and expand all the above projects in 2014. And in 2014 also, the Supreme Court, together with the DOJ and the DILG, under the Justice Sector Coordinating Council, launched the Justice Zone Project. Many of you were with me in Quezon City at that time. Now, it is a locality where a minimum number of interagency coordinative reforms exist. The Justice Zone is guided by an operations flowchart that depicts the lifetime of a criminal case from case buildup to post-judgment incidents such as probation and rehabilitation. The flowchart enables each sector to set their performance targets for their individual sector and automated activities. No longer do judges in silos. Is coordination, even while there is respect for professional independence. One example of such interagency reforms is the e-subpoena, an automated notification system which enables the court to send electronic subpoenas to the emails of police witnesses and the units where they are assigned. The PNP in turn uses the system to attend court hearings. This replaces the snail mail system, where paper subpoenas often fail to reach police witnesses in time. Without the apprehending police witnesses, judges are forced to dismiss cases, especially in buy-bust operations. The e-subpoena system is being used in 58 courts in Quezon City and 14 courts in Lapu-Lapu and Angeles cities. The attendance rate of police witnesses has reached a high of 97% in Quezon City, and for all the three areas combined, an average of 77% in 2015 and 2016. The out in the entire National Capital Judicial Region. In 2015, with the aim of further declogging our court dockets, assisting courts were formed, in which less congested courts from nearby jurisdictions were tasked to help overburdened courts deal with the latter's heavier caseloads. These projects target to decongest burdened courts in Makati, Quezon City, Mandaue, Lapu-Lapu, to be assisted by Manila and Cebu City courts. As of December 2015, a total of 6,397 cases have been transmitted by the Quezon City and Makati City courts to those who are assisting from Manila. Of these transmitted cases, 2,695 have been disposed of by the Manila assisting trial courts. Reports for Mandaue and Lapu-Lapu are to be submitted at the end of the month. Also launched in August 2015, the continuous trial system requires the participating courts to conduct trial continuously in criminal cases. Continuous trial system prohibits postponements unless they are on very exceptional grounds and sets trial dates 1 day apart. Promulgation of the decision is to be no later than 90 days from submission of the case for decision. Rolled out in 52 pilot RTCs and 6 pilot METCs in Manila, Quezon City, and Makati, the continuous trial system has shown that roughly 70% of the pilot courts were able to conduct arraignment of pretrial within 30 days under the rules of criminal procedure, effectively shortening a major reason for the delay. Performance data on the length of the trial itself will be submitted in October. But to give you an example of how enormous the impact of this system can be when it is functioning, the continuous trial system has gained international recognition when the U.S. State Department commended and considered it as a factor for elevating the status of the Philippines on the matter of fighting human trafficking. The International Justice Mission also announced in its website that, open quote, sweeping change is happening in the Philippines, close quote, when a human trafficking conviction was promulgated by a Makati City judge 5 months from the filing of the information. The judiciary is also enhancing its alternative dispute resolution mechanisms. Since its launching in 2009, the Enhanced Justice on Wheels program, or EJAW, successfully improved access to justice through mobile court hearings. From 2012 to date, EJAW resulted in the promulgation of 1,341 decisions, the release of 2,164 inmates, successful mediation of 325 cases, provision of legal aid to 2,656 prisoners, and medical dental aid to 8,498 inmates. Also, since its inception in 2002, our court annex mediation units posted a 62% average success rate for the 348,041 cases it mediated. Its counterpart mobile unit in Taytay, Rizal, also posted an impressive success rate of 91% since its launching in 2007. These programs have already received worldwide acclaim from the different judiciaries. Now, how do we all the above judicial reform programs provide justice in drugs cases. Obviously, they expedite the resolution of drugs cases. But let me add that not only are drugs cases expedited, all criminal cases are being expedited as well. As of May 2016, 128,368 drugs cases are pending before the lower courts, constituting 29% of the 439,606 total pending cases in the trial courts. The already clogged dockets of courts, which we are doing our best to reduce, is not made lighter by the high inflow of drugs cases. In 2015 alone, there was an increase of 47% in case inflows from the previous year. That is, from 37,736 new drugs cases in 2014, it increased to 55,481 in 2015. In the Supreme Court, 469 drugs cases are pending appeal, representing 33% of the total appealed criminal cases as of that day. We have just added 240 more courts to our core of drugs courts, making all 955 regional trial courts as drugs courts. The addition of more drugs courts, the deployment of case decongestion officers to burden courts, the employment of automation, continuous trial, assisting courts, and other reform measures are meant to expedite the resolution of drugs cases at the fastest possible time, hopefully in the same speed with which the human trafficking case was resolved that was noted by the U.S. Department of State. That being said, let me now share with you some of our observations as regards the trial of drugs cases. Many drugs cases are delayed or dismissed for the following reasons: the absence of police witnesses, the dearth of prosecutors or public attorneys, and the weak evidence of the prosecution in relation to the rules on chain of custody and inventory of seized drugs and paraphernalia. We have shared these observations with the Department of Justice and its attached agencies, namely the National Prosecution Service, the Public Attorney's Offices, the National Bureau of Investigation, and also with the Department of Interior and Local Government and the Philippine National Police. In our view, it is ideally required for a continuous trial to succeed that there be 2 prosecutors and 2 public attorneys for every judge. To the credit of these agencies, they have welcomed all of the judiciary's initiatives through the Justice Sector Coordinating Council. And I hope that this productive partnership among all justice sectors will continue. We have shared our concerns with them as well on jail congestion. And in turn, we released guidelines so that the judiciary can help address the problem. Now, under the JSCC's Justice Zone project, excuse me for a while. We were able to conduct sector-wide capacity building initiatives, such as joint trainings on criminal investigation forensics, judicial affidavits and templates, protocol for case management of child victims of abuse and exploitation, and forums on modern evidence management, and also on anti-illegal drugs issues. We have also developed synchronized calendars, which contain all the information on all the official activities of the judges, the prosecutors, and the public attorneys in one area, so that there will be no delay due to scheduling conflicts. And it has produced good results in the Quezon City pilot area. The JSCC also facilitated the deputization by the Public Attorney's Office of the Bureau of Jail and Management and Penology paralegals to file release motions for detention prisoners who are already entitled to be released. And we also facilitated the internet-based consultations between the POW lawyers and the detention prisoners. As a result of continuing dialogue in the JSCC, the court has also agreed to share our inventory of criminal cases to all regional prosecutors to help them in their own case management system. On this note, allow me to make special mention of the release of a high-profile suspect who is also a military official. While the anti-drugs raid received wide and high-profile media coverage, no case was filed against that drug suspect. So our judge was forced to release him principally because there was no longer any legal basis to continue holding him in detention. We request, therefore, that the judiciary not be blamed when other agencies fail to either file the appropriate charges or present sufficient evidence against drug suspects. Let me update you now on the two largest criminal cases being tried in our courts. And may I point out that these are not drugs cases. Other than those pending before the International Criminal Court, allow me to venture that I do not know of any judiciary that is currently facing the magnitude of work that these cases represent. And I refer to the Maguindanao Massacre cases and the Zamboanga Siege cases. The Maguindanao Massacre cases account for 58 victims and 195 accused, with 112 already arraigned. The trials are actively attended by 12 prosecutors that comprise the third panel of public prosecutors, 7 private prosecutors, 27 defense lawyers. The transcript of stenographic notes alone have now reached 52 volumes, while the records of the cases are 114 volumes thick. To expedite trial, the Supreme Court ordered Judge Jocelyn Reyes to focus solely on this case, while 3 assisting judges have been assigned to handle minor motions and other pending cases in her court. Special trial guidelines have been issued to fast-track reception of evidence and to allow her to issue partial judgments. All of this, the court has issued so that the trial can be expedited. Hearings are continuous and thrice weekly. The presiding judge who took over the case in 2010 has already heard a total of 223 witnesses, 131 prosecution witnesses, 34 defense witnesses, and 58 private complainants as of August 2016. She was also able to resolve 12 sets of formal offer of evidence and bail applications of all the accused except that of accused Andal Unsay Ampatuan Jr. As of date, the proceedings have already reached the hearing on the evidence in chief. The prosecution already rested its case after filing 5 batches of formal offers of evidence against 105 accused, and the court already resolved the first batch involving 9 accused. Meanwhile, the presentation of defense evidence commenced last June 29, 2016. Once the defense rests its case, which it has promised to do so soon, these cases will be submitted for decision. Now, an original number of 284 accused after the prosecution amended the information 8 times. There are now 222 accused remaining, with the cases against 52 having been dismissed as followed. First batch, 42 have been released after the investigation. Second batch of 3 also released following stipulations, and 7 died while in detention. We have applied the same rules of procedure we developed to expedite the trial of the Maguindanao Massacre cases to also expedite the Zamboanga Siege cases. For this reason, pre-trial conferences were already held together with the marking of hundreds of evidence. The prosecution is set to present 386 witnesses, inclusive of 2 state witnesses. All the 222 accused shall take the witness stand with 254 other corroborative witnesses. However, following a long period of negotiations and study of the evidence on hand, the prosecution presented its plea bargaining counteroffer to the court early this month. It involves 138 of the 222 detainees, which would effectively leave only 89 accused to stand trial. Once comment is received from the defense and the arguments deemed meritorious by the court, the 138 accused covered by the plea bargaining agreement shall have to withdraw their original pleas of not guilty to the lesser offenses included in the original charge of rebellion. I wish to highlight that expediting drugs and other staple criminal cases, however, are not the only areas that the court is introducing reforms to. To this end, the Supreme Court understands that it can only be as credible as its own adjudicative and internal management reforms can demonstrate. We have broken first-time records, among which are the first time the court has disposed, I'm referring to the Supreme Court, of more than 5,000 cases when it disposed of 5,173 in 2015. As of June 2016, it has already disposed of 3,033 cases for the year. The first time that a physical inventory of the cases has been done of those in the Supreme Court. Three, the first time a joint SC IBP inventory and case disposition program has been done for complaints against lawyers that have been referred to the IBP. Fourth, the first time that the Chief Justice has called for and regularly presides over various management committee meetings with all key officers of the Supreme Court, the Office of the Court Administrator, the 3 presiding justices of the Court of Appeals, the Sandigan Bayan and the Court of Tax Appeals, the Judicial and Bar Council, the Philippine Judicial Academy, the Mandatory Continuing Legal Education, the IBP, and the Philippine Association of Law Schools, among others. The first time that all the processes in the judiciary, in the entire judiciary, both adjudicative and administrative, are being reviewed through a professional process reengineering program. The first time that a document and Rolio tracking system has been implemented in the judiciary with barcoding and all, starting with the Office of the Chief Justice and the Judicial Records Office of the Supreme Court. The first time that we are coordinating and professionalizing our own performance metrics with those of the Civil Service Commission through the judiciary's strategic performance management system and an accounting and auditing system in coordination with the COA and the Department of Budget that is compatible with independent judicial accounting and auditing system. And 8, continuously issuing directives to all officers in the judiciary to take more actions that will prove professionalism, transparency, and integrity. What I have tried to paint for you is an entire systems overhaul and streamlining so that the actual adjudicative work of all courts nationwide is efficient, with all the other pillars of the criminal justice system supportive of each other's constitutional or statutory mandate without impinging on the independence of the judiciary. This systems overhaul and streamlining, however, will benefit not only criminal cases, but also all other cases important to the Filipino. For example, we have increased the jurisdiction of small claims courts over money claims from a ceiling of 100,000 to a new ceiling of 200,000 pesos. We understand the need of our lower and middle classes, especially our OFWs, who have very limited time and resources to go after their money claims, especially with OFWs usually having only 2 weeks of annual leave. In a small claims court, parties testify through affidavits. Lawyers are prohibited from appearing, and courts are required to render a decision within 24 hours from termination of hearing. Forms and templates are made available to litigants for free with minimal filing fees. The average time it took to finish a case under the original sealing was 73 to 77 days. We will soon launch an information campaign to give our people better access to justice and tap the information channels already being used by other government agencies, such as the OWA's pre-departure orientation seminars. There is a remarkable increasing use of this mechanism. As of July 2016, a total of 8,766 small claims cases have been filed in our second-level trial courts, representing a 300% increase from the 2,238 from the previous year. We are in the process of collating all the report on the disposition of small claims cases. With respect to family disputes and juvenile justice issues, our Committee on Family Courts and Juvenile Concerns conducted 2 family court summits, and as a result, draft guidelines are soon to be submitted to the Supreme Court for approval. The draft guidelines are intended to streamline jurisdiction, raffle, and process issues. It might also interest the business community that we had promulgated the rules of procedure for rehabilitation and insolvency cases. For financial rehabilitation, the rules provide for strict timeframes in undertaking specific steps in the rehab process. The stay or suspension order in a financial rehabilitation system is unique in that it covers all kinds of actions, including judgments, attachments, and other court processes. If rehabilitation is no longer possible for the entity, conversion to liquidation proceedings is allowed under the rules. It can abbreviate the economic woes of an insolvent debtor and allow an equitable distribution of the remaining limited resources. We are also extensively training our commercial court judges not only in these rules but also on handling intellectual property rights disputes. Currently, let me tell you what is being studied. We are studying the designation of special cybercrime courts, expediting the rules on government infrastructure projects, addressing the problem of delays in land cases, in estate proceedings, and in cases involving multiple victims or mass civil injuries, such as the 4,000 victims of a famous or infamous sinking of an inter-island ferry. In a future forum, we might be able to discuss the problem and the possible approaches that the judiciary could adopt to give justice in those areas. Now, allow me at this point to debunk a persistent myth. The courts are issuing too many restraining orders against government infrastructure projects. The data appears to be, from 2013 update, the Court of Appeals has issued only a single TRO against a government infra project. And in 2015, out of the 2,039 petitions that were with the Court of Appeals that were praying for a TRO on various subject matters, only 50 were issued by the CA, or about 2.45% success rate for those who want to get a TRO from the Court of Appeals. So obviously, there is no basis for the myth. Now, with respect to the Supreme Court, it has only issued 1 TRO against a government infrastructure project. In any event, since the 1990s, the court has already issued 7 circulars to all lower courts, reminding them of the prohibition in issuing TROs and writs of preliminary injunctions against government infrastructure projects. We are still at the preliminary stage of getting and analyzing all TRO data from the lower courts, but my initial impression from reading the reports is that lower courts are also not issuing TROs against government infrastructure projects. At least I have to see one TRO that falls squarely within the prohibition. I am alarmed by the situation in our country of impunity, whereby court processes are not affected by law enforcement agencies, especially in arresting suspects in the killing of journalists. I will exert effort with the new leadership of the Philippine National Police to ensure that our warrants of arrest are effected, especially against political warlords. The JSCC will also hurry the establishment of the e-warrant system so that whole departure orders and arrest warrants can immediately be effected not only by the police but also by port and immigration authorities. In relation to the problem of impunity, we are also studying the problem of ineffective, delayed, and corrupted execution of court judgments. I view the security of our judges very seriously. Since January 1999 up to date, a total of 26 judges have already been slain while in service. Most of them were ambushed and shot point blank in broad daylight by unknown assailants. I hope to receive complete reports of these killings by investigating agencies, similar to the reports we have received with regard to the killings of judges Lacasandile, Arles, and Nieves. Similarly, we are aware that corruption is an obstacle to development. It is a complex problem which has to be confronted through a variety of independent initiatives to strengthen the integrity and prevent opportunities for corruption among members of the judiciary and the employees of the judiciary. The battle against corruption is a Supreme Court has dismissed 12 judges and 1 Sandiganbayan justice. 18 demanded fined and forfeited the benefit of also disbarred 31 lawyers, suspended from the practice of law 194, suspended from the practice of law and notarial practice 30, suspended from notarial practice 8, reprimanded 39, fined and reprimanded 3, admonished 80, censured 2, warned 6, fined and warned 113, ordered arrested 16, and dropped and stricken off the roll of attorneys 1. All for a total of 716 penalized lawyers since 2012. For lower court employees since 2010, we have admonished 42, forfeited the benefits of 35, censured 2, dismissed from service 16, fined 240, reprimanded 221, and suspended 227. 3 of the most famous administrative investigations have been done on our own initiative or motu proprio without a formal complaint. In addition to matters in the pipeline or drawing board that we have no time to discuss, and asset develop our personnel core of the judiciary, the training programs that we have been opening up for other government agencies, internship programs for law students, bar examination reform, our new international projection and leadership in the region, etc. All of these are meant to establish a judiciary that sets the gold standard for public service, not only in the country, but within our capability to the region as well. It is true that our people must have a reason to trust government. That is why the judiciary has been working harder than ever before. My earnest request is that our 4-year effort to reform the judiciary and the justice system and to bring about an era of honest service by the members of the bench and the bar be supported by our people in the same way that any genuine reform effort in whatever sector must be supported as well. After all, we have only one country to serve. Thank you very much.
Questions from our panel. This year, we have a slightly different format for those who've been following us for the past 3 years. We will have 3 rounds of questions with 2 separate panels. Before I introduce the members of the panel, let me say that we are live on all major networks. You can also follow us through live stream through YouTube. Please go to the Supreme Court of the Philippines channel. And please do join the discussion by posting your questions on Twitter at SCPH_PIO using the hashtag AskCJ Our first panel consists of the members of the 2 reporters associations covering the Supreme Court, the Court of Appeals, and the Department of Justice, which are JUCRA and JUROR. Each group has been given 4 seats, and they democratically selected the panel members themselves. So let me introduce the panel first before I go to the one who will ask the first question. From the JUCRA, from the Philippine Daily Inquirer, Vince Nonato. From,
Hello, Vince.
From UNTV, former Congressman Erin Tanyada. From Business World, Buena Bernal. From the Philippine News Agency, Lloyd Kaliwan. And from Juror, from DZBB, Cecil Villarosa. From ABS-CBN, Ina Reformina. From DZMM, Johnson Manabat. And from GMA News, Virgil Lopez. By previous agreement, meaning they have drawn lots, I think. The first question will be posed by the Philippine News Agency, Lloyd Kaliwan, sorry. Lloyd, you will have 2 questions. You can ask both questions in this round immediately. Sound? Mic, please. Can you pass the mic? There.
Hello. Good afternoon, ma'am. If there are other judges, aside from named by President Duterte, that the court is now investigating for possible involvement in illegal drugs?
There is one. We have just suspended him. The one that I was referring to in my letter has already been suspended. And further investigate, together with the formal administrative investigation, it has already been docketed. We continue to do fact-finding investigation. And we are also conducting fact-finding investigation on another one.
Last na lang. Reaction on the proposal budget increase for judiciary?
Well, we sent a letter for reconsideration by the Secretary of Budget, Benjamin Jokno. We tried to impress on him that we need really the infrastructure budget fully supported. And I just forgot the other items. But in the main, we were able to get a big portion of our request. But I think it is important for him to understand the importance of those items. We are requesting him, well, we are requesting the President basically, and then now that it has been submitted to Congress, I don't really know the final outcome of the request that we had submitted. So now we are going to bring to Congress a request that the following items be reconsidered. The salaries and benefits for the 760 personnel of 50 family courts. The first batch consisted of the creation of 48 family courts. If you remember, I earlier shared with you that while the Family Courts Act was enacted in 1997. It was only last year that finally government, the executive department and Congress gave us money to fund those courts. Earlier, we had just been designating regional trial courts to also assume jurisdiction over family cases. Now that they had provided money for 48, we are now processing already the organization of 50 additional family courts, so that this year and next year we will have a total of 98. The money for next year for 50 family courts was deleted by the executive department, and I don't understand why, considering that these family courts will also be handling drugs cases if one of the respondents is a minor. So family courts are already heavily burdened now. And with the deluge of new criminal case filings that we are seeing, the cases are really spiking, really a cause for concern. We need that money for the 50 family courts to be established. So that is one. And then we also have to have money for the office spaces for these courts to be given. So that's the second item that we are asking him to reconsider. We also need equipment for the first and second batch of family courts. Remember that, if you must know, the law requires that the equipment of family courts and the way that family courts are configured should allow a child-friendly reception of evidence. So that means IT equipment so that we can have a hearing where the child witness need not testify in front of the accused. So we need to lease not only space for our family courts, but also IT equipment for the same. We also were not given any money for transportation. Can you just imagine? We cannot buy any vehicle. I think this is, our requests are very, very, look at it in light of the fact that we have actually been asking for very small sums. And land acquisition, because we are hoping to have a development center for research and education. These again are very small items that unexplainably were deleted from our proposal. So these are matters that we will keep on pressing in the halls of Congress. Lloyd?
Thank you, CJ. Thank you, Lloyd. The next one who will ask is Virgil Lopez from GMA News Online.
Congratulations, ma'am, on your 4th year as
Thank
Chief
you.
Justice. My first question would be, President Duterte fulfilled one of his campaign promises by coming up with the first executive order on FOI. Is the judiciary also planning to come up with a similar measure on FOI as well, or something to that effect, pending the enactment of a law by Congress?
Actually, we need not announce that because we had already adopted that as a policy. If you will remember, we are live streaming all the oral arguments. We have a transparency seal for the Supreme Court, the Court of Appeals, Court of Tax Appeals, and Sandigan Bayan's website and the OCA's website. That's correct, Ted?
Yes, John.
Where you can see all the contracts, all the requests for bids to be submitted. You can see all the financial data there. All the issuance are there. I mean, even the summaries of the SAL-Ns are there. So, to the extent that there is no invasion of privacy, to the extent that constitutional rights are protected and our deliberative sessions are kept confidential, all of the information the public needs to see are actually available.
For my second question, ma'am, in relation to Lloyd's query earlier, do you see the need for the President to convene the JELAC, the Judicial Executive Legislative Advisory Council, at least to address the issues that you have raised earlier regarding budget cuts or whatever?
I have absolutely no idea of the kind of time allotment policy that the President is observing. What I do is to try to raise our concerns with our partners in the JSCC. the Department of Justice, Secretary Vip. I often am in touch with him. Secretary Sueno of the DILG, I also talk with him. The Department of Budget and Management, our budget team is always explaining things to him and to his people. So on our end, we have been communicating actively, and it is really up to the President to consider how his time should be spent. So I'm not in a position to offer any suggestion.
Thank you, Virgil. The third questioner will be Buena Bernal from Business World.
Hi.
Hi, ma'am.
Hi, Buena.
Former Chief Justice Renato Puno took a more proactive role on the matter of enforced disappearances during his leadership of the judiciary. He issued the judicial order conceiving prerogative writs that help solve extrajudicial killings. Under a Sereno court, will proactive role as well in given the rise of summary executions today.
We have been using the writs of habeas data, the writ of amparo, quite actively. Now, I think your underlying question is actually, are they effective enough, sufficiently effective? Now, all of these prerogative writs, which the Supreme Court is authorized to issue under the Constitution's Article 8, Section 5, presume that there will be sufficient cooperation by those who can do the investigation. You must remember that the judiciary does not have a single field investigation officer. It keeps on requesting help and issuing directives to the investigating agencies. And the hope of the people is that they will do their mandate. We are very proactive as we can be, in trying to ensure that constitutional rights are to be respected. But you must remember that our role comes in when a justiciable controversy is before us.
Second question, ma'am. Are there updates so far on the over 200 courts that you assigned for the drug-related cases last July? Updates so far?
Updates, well, they are already awaiting the guidelines that we are currently discussing in the NBank case. If they are, cases are already being raffled to them. Drugs cases are already being raffled to them. So that maybe one benefit of this is that you are not going to be singled out as a drugs court case, as a drugs cases court. So I think that when the cases are going to be distributed evenly, that would be helpful to the morale of everyone in the judiciary.
Next up will be Ina Reformina, ABS-CBN.
Good afternoon.
Hi, good afternoon.
Then there's been a spate of killings, widespread killings involving, or the victims of which are suspected drug offenders, ma'am. What are your personal reflections and thoughts on these? Because there is a sentiment that this may be brought about by a common frustration and utter frustration in the criminal justice system, of which the judiciary is a very important pillar. When people take the law into their own hands, it seems that there is already an exasperation that they may obtain speedy and genuine justice before the courts. What are your thoughts on these, ma'am?
I took careful steps. I took care to ensure that I give you a full report. Without the need for me to editorialize, I thought that the statistics I just read out to you would themselves prove that the wheels of justice are hastening and that systemic problems that had bedeviled the justice system before are being addressed the way they should be addressed. Not episodic, not isolated, but all understanding the process flow and the efficiencies that must accompany each step so that justice delivery can be efficient. Now, frustration is a function of time. Time for us to prove that judicial reforms are here to stay and that they will be widespread. But I had also expressed concern about the ability of the prosecution services and the public attorneys to keep up with the very fast pace in which the judicial reform is being undertaken. As I told you, the ideal mix is for every court that there would be 2 prosecution lawyers and 2 defense lawyers so that we can conduct continuous trial day for the entire morning and afternoons. So people must believe that things are already being done. I hope there will be people who will hearken to the call of Secretary Aguirre when he said we need more than 500 prosecutors to populate our ranks. I think the same is true also with the public attorney's office. I think the lawyers should consider serving government this time and not just being in the private sector. If the right combination of human resources and technology resources are provided, I think people will already see justice being served fast. I gave you the case, the human trafficking case, because it was the one that garnered international recognition. I had not bothered to tell you about cases I had observed firsthand that have been very fast, simply because I wanted to impress upon you that even third-party observers are already noticing the wheels of justice processing very fast. So there is a second part to your question. So the first part is that the case I'm making before everyone is that things are moving very fast. But I need also the prosecution and the defense lawyers to also put in their necessary work. The second part, I think, is whether killings can be rationalized by frustration with justice. Do they? Does frustration justify killings? I think this is a question you can answer very well.
My second question, ma'am. I was contemplating on asking you if there are moves now to amend the rules and procedures governing trials before the lower courts so as to abbreviate the process without necessarily jeopardizing or compromising due process and rights. But you mentioned quite a few, ma'am. So I would just like to ask for a bit of details regarding practice guidelines. How is it envisioned to shorten trial time but still delivering efficient justice, as well as continuous trial system? When do we expect its full rollout, since it's still being piloted in Manila, QC, and Makati?
Okay. With respect to the Quezon City practice guidelines, postponements are to be the exception. That's a major rule. And then if judges are very strict about that, you can immediately see that that will be very fast. Affidavits instead of direct testimony are being required. So that already takes about 2/3 of the testimony taking time. Dilatory motions and length of pleadings are also strictly regulated. So now you have, from the average observed length of time of 700+ days, it has now just been shortened to 200+ days for a criminal case to be fully expedited. So that's, in broad strokes, that's how fast things are in Quezon City right now. And the automated hearing, it used to be before that when a motion is heard by a judge, the judge will usually say, okay, submitted. And then over the weekend, the judge will go over the records and dictate or write himself an order. He will give that to his stenographer. The stenographer will give it back, so and forth, until it is finalized. Then it is given to the mailing system, and snail mail is the game. So 2 weeks to issue that order from the court, a month or 2 for it to be received by the parties. So that's effectively 2.5 months. Now, under the automated hearing, the motion is immediately heard. The judge verbalizes his order in open court. The stenographer is taking down the notes So the computer of the judge and the stenographer are linked together, so that the stenographer sends the file immediately to the judge sits down and look at the file, this is with everybody still there, and edits the same. The most dramatic illustration of how game-changing this is when one of our judges bought a screen, put it behind her, and then when she was editing the order, everybody could see that she was editing the order right there and then, just after the counsel sat down. And then the judge sends it back to the stenographer prints it, hands it to the judge signs it, then the order is immediately served on the parties. 15 minutes, it can be done. So it is so shocking, in fact, for some of the lawyers. They were so happy that they took selfies with the order and the judge, saying that it is a psychological breakthrough. Can you just imagine? Using the best the technology can offer, it can be done. So I don't see any reason now why we should even think that it will be like it was before. No, things are changing so dramatically.
Thank you.
Thank you, Ina. Thank you, Chief. The next one will be Vince Nonato of Philippine Daily Inquirer.
Hello, good afternoon, ma'am.
Hi, Vince.
May I ask for an update regarding also on the drug investigations? So did the PNP and PIDEA submit their complaint as invited by the High Court a few weeks ago? And what prompted the Supreme Court to make the order an invite for them to formalize the
Well,
complaints?
I think Attorney Te might have informed you of the reason. If you read the whereas clause of the resolution, it said that the resolution says that President Duterte has already clarified that it was only for purpose of information. So we cannot really treat it as a complaint by any person. So on our own, motu proprio, we therefore ordered that an investigation be conducted. And because there is no formal complainant, we invited the PNP head and the PIDEA head. The orders had just been recently served on them, I think Tuesday for the PNP and Friday for PIDEA. So let's await the response.
Ma'am, for my second question, what do you think about the propriety of some justices going on courtesy calls to the Malacanang? Wouldn't this have anything on the judicial or on the separation of branches?
I hope not. In other words, I had already articulated before when I was being interviewed for the position of Chief Justice that not only must we do things correctly, we must be perceived as giving no occasion for people to doubt our independence and our integrity. So that even my socialization with those who are potential litigants and who are actually litigants have been strictly circumscribed by the need to always project independence and integrity. That is the call I consistently make to everyone in the judiciary. I hope that the public does not develop the idea that it was a breach of that line. It is for me, it's a bright red line you must not cross. And my hope is our people support the judiciary's bid to be truly independent.
Thank you, Vince. Yung susunod, Johnson Manabat of DZMM.
Hi, good afternoon, ma'am. Ma'am, the President already apologized to you, madam, and Attorney Tess says that you appreciate it. The question is, how would you describe, ma'am, the working relation of the judiciary and the Malacanang under the Duterte administration?
Well, my official contact with the executive department is largely through the JSCC. That is with Secretary Aguirre and his attached agencies, and with Secretary Sueno with his attached agencies, together with the PNP. We will need to have a continuing healthy relationship with the executive department. Because even assuming that the judiciary is able to implement all its reform programs. If the evidence is weak, if the investigation is not professionalized, then our people might still have a reason to be concerned about the delivery of justice. So I describe it in the way that I would describe an imperative. I need to have very good relationships. We need to have very good relationships with the executive department. Regardless of which administration is in power, judicial reforms are not just for one administration. They must be here to stay. They must be sustained. Our people must be taught to depend on and demand higher and higher levels of accountability and performance.
Thank you po.
Next question.
My second question is, Madam Chief Justice, how would you assure the public now that there will be no constitutional crisis with what is happening with the President saying a lot of information about some members of the judiciary?
Well, you know, I am not God. So, my role is to ensure that the judiciary's role, that the judiciary's duty is properly discharged. Whatever the reaction could be, many times, the judiciary is just all too aware that people can sometimes take offense, because in any given case, one side will always be angry with the judge. I haven't seen any losing litigant happy. So we are used to people not being happy with our decisions. But the strength of the judiciary is to continue doing what is right, regardless of.
Thank you, Johnson.
Thank you po.
The next questioner is Attorney Erin Tanyada of UNTV.
Good afternoon, Madam Chief Justice. You mentioned in your ulat the Maguindanao massacre. We're on our 6th year. Last year, you've mentioned the possibility of a partial judgment. Do we see this coming soon, considering that there are certain situations? I also remember last year, Madam Chief Justice, you also mentioned that the judge sitting on the case may be promoted. She decided to stay and finish the case altogether.
I'll wait for Attorney De Dumo to give me the screenshot of the text message I got. All right. Remember, August we met last year, and I was hoping for a reasonable conclusion within the foreseeable future. All right. And I said that the defense was actually making promises at the time. All right. August 7, 2014, the counsel of the accused, Fortuna Narvasa and Salazar Law Office, withdrew. Okay. So Attorney Salvador Panelo came on board. He did not immediately start presenting rebuttal evidence, but he asked for an extension period, which the court granted. This was the first time that the court allowed an extension, because the court was under strict instruction to make sure that everything is expedited. But what could the court do? He was a new lawyer, so it seemed reasonable that he should be given some time. On September 2014, that was after my second ulat, he committed to start presenting rebuttal evidence starting December 2014. And then, afterwards, he moved to present this evidence in February, 2 months after his original commitment. That was only the second instance that the court allowed an extension. Again, at the instance of the defense. After about 5 months, in July, the court directed counsel to finish his presentation by October. That was why I was saying I hope that we could have a fast conclusion, considering that the hearings were only for the bail. October 9, he moved to extend the last presentation to December 2015. That was only the third instance that the court allowed an extension. Then in December, he withdrew 2015. So what could the court do? It cannot proceed unless the accused, especially the principal accused, had counsel. So in January 2016, we had a new counsel, Attorney Manuel, who entered his appearance. So he also did not immediately start his rebuttal evidence. He asked for a 1-month extension, and he was given until February 18, 2016. Fourth time that there was a... Instead of presenting on February 18, he again moved for several resetting. Fifth instance for the extension. And so we were also, there were several extensions after that, and there were numerous cancellations of the hearings, and there were 8 instances of cancellation. So what we now have is a court faithfully observing the instruction of the Supreme Court to make sure that the hearing proceeds and does not encounter delay. But this must be balanced by the rights of the accused, which in many instances the court could not avoid granting extensions. So that is the reason why we are only now seeing the but the good thing about this is that we are already, the prosecution has already rested its presentation of the evidence in chief. So hopefully the defense will live up to its commitment to expedite also their presentation and terminate the same.
Second
So
question.
I hope that you can consider this as outside of the court's control.
Second question, Madam Chief Justice. I don't know if you would like to answer this. What prompted the Chief Justice to write President Duterte the letter?
It was a letter of concern. The concern prompted it.
Thank you, Erin. The last but not the least, Cecil Villarosa, DZBB.
Good afternoon, Chief Justice. My question concerns about the case congestion because I come across a study conducted by the Asian Development Bank, ADB, Asian Development Bank. And according to ADB, it may take 20 years before the courts can be cleared of pending cases.
How many years?
20 years pa daw po. But based on the figure given to us by the Supreme Court PIO, as of December 2014, the total number of courts in the first and second level is 2,480. But there is a vacancy of 778, which means to say there is a 31% of the position in the first and second level courts is not filled up. Madam Chief Justice, do you think that if that 31% vacancy will be filled up, would it be enough to address the current case congestion? Because according to the judges in the Manila Regional Trial Court, their annual average case load is 300. And the figure is higher for those judges who handle special courts, which is 500 cases per year. And don't you see the need, ma'am, to create additional courts, especially here in Manila?
The Congress has already passed many laws creating more courts. The vacancy rate is not 31%. It is 18. Am I right? 18%. And
But that's as of December 2014, based on the figure given to us, madam. So sorry. So 18% na lang po. Okay.
December 2014. Okay, that's a year and a half ago. Okay, it's only 18% now. The reason why we are cutting down the vacancy rate is because the JBC is so fast. Just imagine last year, 2015, they were able to process 7,000 applications. I don't know of any recruitment agency that processes 7,000 applications. So you can see that the JBC members are working very hard. So I don't think we lack judges or courts as much as we lack prosecutors and public attorneys. I think that's the greater part of the problem. Because in many courts right now, they can only set hearings once a month because one prosecutor is being shared among 6 courts. So just imagine how hard the life of the prosecutor is. So that's the biggest problem, I think, in the criminal justice system. Now, the courts are already being automated. So, you know, the figures that he gave for Manila of 300 cases, I don't consider that as a burdened court. That's a court with a light docket. Some courts have cases as high as 4,000. You see, when I came in, I started looking at the figures. I was so shocked by the fact that the cases are not distributed evenly. Drugs cases would usually have at least 1,000 cases on their docket. Commercial courts would have small dockets. Family courts will have about 500, 900, 1,200 dockets, but regular courts will have about 600, 400. Now, the disparity in the cases is also very marked between courts in cities as well as versus those in rural areas. In Metro Manila, the most congested courts are in Metro Manila, and it's not the same. The most congested courts in Metro Manila, I think, is Quezon City, followed by Pasig, followed by Makati, and Manila is actually an area where courts actually don't have as heavy a docket. But many courts were created for Quezon City. If I remember correctly, 22 courts. 22 courts were already created for Quezon City. So we will already have a major reduction. That's why when we have our case decongestion officers and reform programs, we really look at the existing dockets. Our case decongestion officers are being distributed nationwide to dockets of more than 500 cases. These are law graduates who are going to be trained on how to make a case decongestion plan. They record each incident in a case, really a very time-consuming way of recording all the incidents and giving the judge an idea of how to manage his cases and classifying them according to those which are delayed, those with detention prisoners who should already be released. So this has been very effective in all the areas that we deployed case decongestion officers to. Okay, so you need a menu of solutions, not just one. There is not just one solution that fits all the circumstances. You look really at the statistics, and that's how you do your redeployment. But the other phenomenon I am alerting the public about is that so many cases are being filed by the Department of Justice. It might be a fair question if there is a quota or something that they're trying to meet. But they don't have enough prosecutors to prosecute those cases. So what will happen? No matter how hard our judges are trying to dispose of pending cases, the influx is just so dramatic. And then when they come in, they are not prosecuted. So we are actually talking about asking the DOJ and the PAO to really prepare for continuous trial, because that should be the standard already. You file a case, you finish the pre-trial conference within a fixed time, you finish the decision 90 days after the case is submitted, after the hearing, and the hearings are set 1 day apart. That should already see criminal cases, the simple cases, being decided within a year, 2 at the most. The question is government able to provide the prosecutors and public attorneys. Are they really doing their job by increasing the number of filings? Is there a duty to ensure that the cases they are filing can be prosecuted?
My-
Next question, Cecil.
My second question, ma'am, concerning about your effort to get rid of corruption in the judiciary. Ma'am, any update on the Ma'am Arlene case?
And
Ma'am Arlene case po.
okay. The election format that gave rise to the charges of following the rules on modesty, etc. Okay? That systemic problem has been addressed because judges now are being elected to the Philippine Judges Association electronically. So we now have electronic voting. So nobody has to entertain anybody anymore in expensive hotels. One of the 4 judges being investigated has already been dismissed for corruption. One of the 4 judges being investigated has already been dismissed for corruption, Judge Rubia. Is Raul here?
Good po.
Ted,
Yes.
si Judge Rubia.
Si Raul.
DCA Raul.
Yes.
It's Judge Rubia? Judge Rubia was already dismissed. Okay. But this is not in connection with that particular controversy, but because of a prior case that had been pending before him. He was already being investigated beforehand. We could not proceed with the conflict of interest investigation because the private party who was involved left the country. So one of the judges who was being implicated was moved back to the original station in the north. In other words, there is an effort to quarantine the problematic court where, according to rumors, that private person had influence that had already been quarantined. There are further issues that are being looked at by the court at the moment.
Thank you, Chief. Okay, thank you to our panel, Lloyd, Virgil, Buena, Ina, Vince, Johnson, Erin, and Cecil. Now we go to our second round. This is now an innovation that we're doing. We're taking questions from social media as well as using videotape questions. Let's take some questions from Twitter. First question. Chief, the question is from Danito Pedring, at Danito Pedring. Ang tanong niya po, pwede po ba na magkaroon na din ng petty crimes court para sa kaso na ang parusa ay hindi tataas ng 1 buwan?
Pag-iisipan ko pa yung question mo kasi parang hindi ka satisfied sa first level courts. Bakit tayo, pabilisin na lang natin yung ginagawa na first level court. Mahirap na gumawa ng bagong court just for this.
Thank you, Chief. Second question from at Rebel Rome 13. How do you think your dignified silence mantra will affect the public's perception of the court as a whole?
Well, you see, mantra has religious connotations, no? So I will not use the word mantra. All right. Remember that when I issued the first statement I made when I was appointed as Chief Justice, I was trying to let everyone recall the golden days of the court when we were read more than we were heard. That we would make our voices felt by the erudition in our decisions. That is the intention. The intention is to allow enough space between the court and the public so that its dignity will be maintained. You cannot have a court that will speak from every corner, every street corner, joining those who are espousing a cause left or right. The moment you allow the judges to speak that way, you will be eroding the required professional distance that we must maintain so that when the cases reach us, we can basically say we are not in a conflict of interest situation. If I may be allowed to rephrase the question, I think what the viewer, the tweeter really meant to ask was, can you try to communicate more with the public so that we can understand the work of the court? In the same way that the executive easily opens its window to the public so that it can be understood, to the extent that you can see the legislature having politicians giving media interviews often. Now, I must emphasize that that is not the role of the court. If it were so, we would not be able to preserve the confidentiality of our deliberations. We would not be able to avoid having to inhibit ourselves because people suspect our motives or our partisanship. Ang pagpapaliwanag na lang po namin gagawin sa hudikatura, katulong ko po dito si Attorney Teddy Te at ang kanyang magigiting na kasama sa PIO, gayon na rin po yung aking expanded communications group sa buong hudikatura. Ipapaliwanag po namin kung bakit po importante na mayroon tayong due process at mayroon tayong rule of law. Gaya po ng sinabi ko kanina, yung sa small claims po, halimbawa ho kayo ay nagpautang sa inyong kapitbahay kasi nagkasakit yung anak niya ng 50,000. Tapos, gumaling na't lahat yung anak niya, hindi pa ho nagbabayad. Kayo naman po ay may tuition na kailangang bayaran para sa inyong mga anak. Di nagpapanik na ho kayo. Pumunta na ho kayo sa pulis, pumunta na kayo sa barangay, hindi nyo pa rin makuha ang kailangang hustisya na maibalik ang pera nyo. Ang ginawa na lang po ng korte, gumawa ho ng rules para yung mga maliliit na away na po yun, matapos na lamang sa paggamit ng mga affidavits bilang testimonya. At hindi na ho kayo kailangang maghanap pa ng mga abogado. At napakaliit po ng filing fee. Magsisimula po ito sa kababaan ng 500 piso lamang. At yung mga template na affidavit na kailangan nyo pong punuin, pwede pong bibigyan kayo ng mga small claims courts na ng form mismo para i-fill up nyo na lang po yung mga blanco. At yun po, ihahatid namin sa buong bayan, meron na po kaming small claims para itong maliliit na pang abala sa inyong buhay, madali nyo na pong asikasuhin. Yan po ang gagawin namin. Pupunta ho kami sa inyo at sasabihin namin anong mga paraan kayo makakakuha ng access to justice using the procedures that are already in court. Isa pong paraan rin, pagko-communicate namin, yung mga buses po namin, yung tinatawag nating IJAW buses, pumupunta po yun sa mga liblib na lugar kung saan hindi ho maraming korte. At in a marathon session, tuloy-tuloy po ang hearings at marami hong nadidismiss na kaso na at napapakawalang mga bilanggo sa pamaraan na yon. Ngunit, ito po ang kaya namin gawing communication program sa inyo. Pero yung amin pong silensyo sa controversial issues, it is constitutionally required. Kung kakampi po ako sa partido A, right now, dito sa interview na ito, at sasabihin kong, ay, hindi naman tama si partido B, paano po kung pupunta sa amin sila at hihingi ng ayuda, ay kailangan ko hong magbitiw sa pag-upo bilang mahistrado. Kaya't kailangan po mas malimit, tikom ang bibig namin. Kailangan po yun ng hustisya. Hindi po dapat madaldal ang hudikatura. Salamat po.
Thank you, CJ. The third question is from @SCWatchPH. What's the most difficult decision you have to make so far as Chief Justice as a lawyer?
marami hong mga kasong napakahirap po pag-isipan, pag-aralan. Kayo, yung iba sa inyo, nakaka-attend na ng oral arguments, nakita nyo kung gaano kahirap po yun. Yung malimit po doon, nagpupuyatan kami at nagtatrabaho pa sa weekend just to prepare for one oral argument. Yun ho ang nakikita nyo. Ang hindi nyo ho nakikita, yung nagde-deliberate kami internally, napakahirap po ng mga debates na nangyayari doon. Even when you are actually drafting a decision, just to read a rolyo, napaka mabusisi po. Napaka mabusisi po. Ngunit kung kailangan ko pong mag-generalize kung anong pinaka mahirap gawin. Ang Pilipino po masyadong nagtitimbang ng consequences. Natatakot malimit, gawin ang tama, o sabihin ang katotohanan. Dahil mabigat ang maaring mangyaring kapalit nito. Karamihan po natatakot ang karamihan ng nabalikan sila sa isang bagay. Ngunit ang isang huwes po, kahit anumang maging consequence ng kanyang pagtayo sa isang posisyon, sa isang kaso, kailangan niyang tanggapin ito. Maaring magalit masyado sa kanya ang pinaka matitindi at pinakamalalakas na personalidad. Ngunit hindi siya dapat matinag. Maaring bantaan ang huwes ng mga criminal syndicates. Hindi siya dapat mangimi na i-convict ang dapat i-convict. Palagay ko, ako ho ay isa lamang sa maraming matatapang na huwes na handang harapin ang mga pagsubok at handang humarap sa isang komplikadong buhay dahil mayroon pong consequence ang aking mga paninindigan. At the same time, in every move that I have to make, it must be guided by wisdom. Ito ba ay pagtatapang-tapangan? O ito ba ay posisyon na ito ay dahil sa masusing pag-aaral kung ano ang tama o mali? Kung kaya ko pong sagutin sa kaibuturan ng aking puso na malinis ang aking konsyensya at ako ay nag-aral ng masinsinan upang makarating sa isang conclusion, maluwag po sa aking loob, natayuan ang posisyong iyon at harapin kung anuman ang consequence. At araw-araw ho, kailangan gawin yun ng bawat huwes. Mas mahirap lang po siguro sa sitwasyon ko kasi ako ang leader ng hudikatura. Mas binabantayan po ako ng maraming tao. Mas sinusuri ang aking mga galawin. Ngunit ang batayan ay pareho. Integrity in the inward parts. Meaning, when I look at conflict of interest in resolving the conflict of interest situation, I always have to come to the conclusion that yes, my conscience holds that I have no inherent bias or prejudice, or I am not in a conflict of interest situation where I cannot judge fairly. Because if I cannot judge fairly, then I must recuse myself. So that is a constant self-examination, and I must do it not only with respect to my adjudicative role, but also in administering the court system. Whether it be in awarding damages or imposing penalties on errant individuals, that sense of fairness must always be seen in the Chief Justice. That is why I must constantly remind myself that I must show respect for people, professionalism, and the virtues that are required of a judge in the most excellent way. So, ganun po ang aking internal processing.
Thank you, Chief. The next question is a follow-up question to your previous statement, Chief, on impunity from Ai Makaraig. Can the CJ further elaborate on this statement? What can be done to address this? The statement is that you're alarmed by the situation of impunity in our country, whereby our court processes are affected by law enforcement agencies.
Allow me to talk about the killing of journalists and one specific case of Marilyn Esperat. I have tried to I tried to get the cooperation of the previous PNP chief on this matter, but the feedback that I got was just a status report that could not be acted upon. What I do want is that all the warrants of arrest that we had issued, especially against political warlords in the provinces, that they be effected immediately. It is so difficult for our courts to believe that their work means anything if after bravely issuing a warrant of arrest against a very powerful individual, the police will not effect it at all. I will try again with this new leadership. I hope the turnout will be better this time.
Thank you, Chief. One more from social media, from @JLawrence. What would you miss in Padre Faura the most once the Supreme Court moves to BGC in 2019?
I would miss the cheaper prices in Padre Faura. Definitely, the cost of living in Manila is far lower than in the BGC. Knowing, however, that all our employees are living on government salaries, I will actually be implementing mitigation measures to make sure that our move to BGC does not mean a dent in their take-home pay. A further dent.
Thank you, Chief. Okay, we have a few videos which we crowdsourced. We'll play 3, and then maybe if there's time later, we'll play a few more. The first video is from a 4th-year student at the Ateneo Law School, Frances Angela Estipona.
Does the judiciary have any monitoring mechanisms in place to track the performances for judges and justices?
Yes. Yes, Pa.
The judiciary has, as I earlier mentioned, has implemented a strategic performance measurement system. And it's slowly being rolled out in the lower courts so that we can monitor their performance. Because right now, the only indicator of performance is how the number of cases that are pending before them are being reduced. We have no performance metric for the quality of their work. We have not yet analyzed the data sufficiently so that we can measure their performance over time, in what kinds of cases, and when they are in fact made to bear additional duties as assisting judges, pairing judges, or acting presiding judges. With respect to justices, the CTA and the CA have quite a workable performance measurement system. In the Supreme Court, we are currently looking at our performance targets because we have noticed that some cases are very, very complex and very, very long. For example, I was given the Lenny Villa case, and you see the killing took place in the early 2000, and the case volume then was already one trolley full of records. Of course, that one case alone took several months to finish, and it was not an easy job. On the other hand, there are cases that are very easy to resolve. We must go through a system of classification of these cases so that we can have a reasonable performance measurement. But we are always discussing how to measure our performance. The only thing that I can conclude right now is going by the sheer numbers and observing how the court is functioning, where everyone is just putting his shoulders to the wheel right now. We have broken records in case of disposition last year. I think we're going to break another record this year, but I don't know how much more at this point we need to do at this point. in order to keep everything current.
Thank you, Chief. The second question on video is from a lawyer. He is the head of the Legal Division of Capital Markets Integrity Corporation, Attorney Martin General.
Good afternoon, Chief Justice. I am Attorney Martin General. I work for the Capital Markets Integrity Corporation, a subsidiary of the PSE. So before President Duterte, the last lawyer who was elected as President of the Philippines was Ferdinand Marcos. So my question is, do lawyers make good presidents? Thank you.
There are good lawyers, there are bad lawyers, there are good presidents, there are bad presidents. So, is there a one-to-one correspondence? I don't think so. I think it really depends on character and competence more than anything. We can await the end of President Duterte's 6-year term, and then you, the public, not me, can make the judgment.
Thank you, Chief. Last question on video is also from a lawyer from the same company, but this is an interesting question that asks for your advice for lawyers. Attorney Natasha Fortea.
My question is, what is a typical day in the life of a Chief Justice?
I get up anywhere from 5 a.m. to 7 a.m. This is too private already. Okay, just to...
You can invoke your right against self-incrimination,
No,
Chief.
but this part I want to share with you. After which I start preparing breakfast. And after preparing breakfast, you go to the shower, and usually before breakfast, I go over some papers that I brought home from work. And then my husband and I take breakfast together. Then I go to the office. Then from the moment I hit the office all the way until I leave, sometimes very late in the evening, then it's all work. All work. I do not have many social activities because I need to cut down on them because the work of the Chief Justice is just overwhelming. So I rarely go out to answer invitations to parties. My weekends are spent resting at home, playing with my granddaughter, going to church, and then preparing for next week's work. And if I have brought home also case documents, I also start reading them and doing a bit of research and outlining my legal strategies and giving instructions. Anyone who works with me closely know that they can receive a call from me at any time of the day and even on weekends. They need to work very hard and long hours. They need to be ready to not sleep at all. Everything is on a strict timetable. The targets are very clearly set. But as you can see, it is a very busy life, but a very simple life. Work, family, church, some relaxation, watching TV. But I think that's how anyone who wants to preserve the ideals of the office should live.
Thank you, Chief. If we have time later, we'll go to some more questions from social media. But we now go to our second panel for our third round. And here we have invited 3 very special guests. Let me introduce them one after the other, and I'll ask them to go to the stage as soon as I introduce them. First, let me introduce Dr. Michael Tan, Chancellor of the University of the Philippines, Diliman, and a columnist for the Philippine Daily Inquirer. Dr. Mike is a doctor twice over. He holds a Doctor of Veterinary Medicine degree, as well as a PhD and a master's degree in anthropology from the University of Amsterdam and Texas A&M University, respectively. Our second special guest is Malu Mangahas, Executive Director of the Philippine Center for Investigative Journalism, a veteran journalist. She was the editor of the Philippine Collegian, also chair of the University Student Council. In 2013, she was awarded Journalist of the Year by the Metrobank Foundation. And our last guest, not the least, of course, Ms. Melinda Quintos de Jesus, Executive Director of the Center for Media Freedom and Responsibility, CMFR. This panel is intended to be a more free-flowing, more informal panel, so please feel free to jump in anytime. There's no specific order. Maybe, Mike, would you like to start us off?
I wanted to start out by thanking Ted and the Office of the Chief Justice for inviting me, and I guess I could speak for the others as well. There's a real need because I appreciate your comment about maintaining a distance. At the same time, we know that it's so important for people to know what the judiciary is doing, and reading the reports, I realized how very little I knew. I always thought I knew, from our civics classes, we know where the Supreme Court is. Pero ang dami pa ring gaps dito. I promise actually after this to give more time and attention to looking at what's happening. After all, we have a law school in UP Diliman. It's important to keep in touch. I'm not going to speak as a veterinarian. I'm not going to speak as an inquirer columnist. Ang naisip ko dito, I'd like to use my anthropologist hat. And we anthropologists, we're interested in what's going on at the ground level. And my concern really is, we've used the word perceptions a lot. And what is it, how do people perceive the judiciary? We know that there are frustrations about what they think is slow justice. And it's said that this is what propelled President Duterte into power. But I think there's a more important, there's something that people often overlook. And this is, I'd like to go back to, may nagtanong kanina if there's a way to deal with the petty crime cases. And I understand this is being dealt with at the barangay level. But there seems to be a disconnect. The barangay level is not part of the judiciary, right? It's part of local governments. But for people, that is the justice system. And I have to tell you, it is very alarming. I've attended many of the sessions there. You'll see barangay captains slapping the person being accused. The tanod, bugbog sarado ang mga suspects. And this is what people see and appreciate, unfortunately. They think this is the justice system that we should have. Mabilis, brutal, pero mabilis nga. And I think they want to see that now at the national level, although many people are regretting it. But this is what might actually prevent us from, if people are saying, bakit tahimik lang mga tao? Because ito ang nasanay ang mga tao. It's a brutal form of justice. I just wonder if the judiciary might make that connect. And I'm so glad you're doing the small claims courts and the others. But there is that weak link that we might have to deal with. It's just an initial comment to get things going.
Hello. I read your columns, Mike, and I like anthropology columns. So that goes for Randy's also, no? So I have been having talks, in fact, with Ambet Ocampo, and then we have been talking about what is the Filipinos' concept of justice. You see, when we had our experience with creating the formal legal system, ang ginamit po nating huwaran ay yung galing sa mga Kastila at galing sa mga Amerikano. May mga assumptions po dun eh. In other words, before they came to that point where you had the Bill of Rights, there had first to be a 1215 Magna Carta, where King John was forced to really recognize that you had to have fairness in the form of a court that adjudges whether a person is guilty or not, and that the crown cannot just decide who will live and who will die. In all its theoretical concept, it is really very laudable. But the problem is that
it has evolved for more than 800 years in these countries before they could really say that they have a justice system that seems to be quite professional and independent. But ours is, it is related to the way that our history as a nation developed. We didn't come out in our barangays evolving their own systems until it became a mature system. We had a system that was fully embodied in several very sophisticated documents that were being implemented already. That's why in the 80s, there were attempts not only to have a barangay justice system, but also the indigenous law movement also began. And it has ripened into the National Commission on Indigenous Peoples and the IPRA, where you were basically recognizing property rights that was not formerly recognized by the Western legal system. The barangay justice system is also an attempt to indigenize forms of justice. Now, you come to the point where you are objecting to the physicality of the barangay system. And you were asking in what way the court, which has a formal system, can interact with the barangay system so that the physicality of the system is mitigated if you indeed find it objectionable. Is that your question, Mike? Okay. I think that obviously the work of the court to promote the rule of law requires much to be done on our part. We need to impress the people that when you have an impartial judge adjudicating right or wrong, abuses that lead to unwarranted deaths, even of innocent people, will be avoided. Or at least there is a way by which people will have a way of trying to verbalize their analysis or their position on a conflict without facing the possibility of being slapped around or kicked. It has to do with the concept of human dignity, I think, Filipinos have for each other. I think that perhaps it is even related to the query regarding the dignified silence of courts. While you say that the silence of courts, the dignity being sought to be established is important, we also have to reach out to impress people that more than anything, what will allow us to survive as a nation is the rule of law, where everyone can say, I must have my day in court, able to prove my innocence, and not being adjudged immediately guilty. Just imagine, I keep on thinking about what it does to the soul of a nation if we are just so ready to pronounce the guilt of a person without even hearing the most basic of evidence. So, I am concerned about the deficiency that I see in our need to respect human dignity. But that is a function of culture. That is a function of education. Our educational capability is quite limited, only in the rule of law area and in the processes that are being undertaken. But my question also for the other agencies of government, to what extent are you promoting respect for the most fundamental values that allow us to live with each other peacefully as human beings? How are they being propagated? Tinuturuan po ba sa ating mga eskwelahan ang respeto sa kapwa? Ang huwag paghuhusga sa ating kapwa nang hindi pa natin naririnig ang ebidensya? Ang paggalang sa mga karapatan ng ating mga kapwa, kahit man mahirap o mayaman, at tayo po ba ipantay-pantay ang tingin talaga sa lahat ng nilikha ng Diyos? Ano po ba ang ginawa ng ating educational system? Paano po ba iniimpluwensyahan ng media ang pag-inog ng ganitong kultura na nakikita nyo na ngayon? Sana po, I think behind this mic also is a sense of fear that we are so insecure in our own homes, in our personal effects, even in our own dignity and privacy. There is such a level of insecurity that there had to be a dramatic demonstration of the ability to control situations and events. Belief in our communities, the belief that we can communicate as a nation, that has to be propagated. And I hope we will have more role models, those who show how it is to respect people. More role models should come forth. And perhaps you from UP could find out the best examples. In the judiciary, I'm starting to pick up stories of homegrown ideas of judges on how to expedite cases. We are compiling a case book called Best Practices that have evolved. Maybe we can pick up good stories, how Filipinos are really trying to build a good, a nation that they can really be proud of. So I am hopeful that because we are a young nation, we only really started conversing with each other after martial law. And so I think, I am sorry, I do not believe that we really were a genuine democracy at the time when we thought, and we were calling ourselves the first democracy in Asia. I really don't know whether we have really fully understood the responsibilities that are required of us as a democratic nation.
Miss Chief Justice, may tatanong lang po ako. Pag sinabi po nating rule of law at due process, pwede po bang matanong dito sa war on drugs, have you done an audit of how many warrants of arrest, search warrants, have been filed by the police to cover the operations? Kasi ngayon po, ang bilang nila ng napatay, mga lagpas 600, ang bilang ng mga nahuli, libo-libo, at ang mga nag-surrender ay 100,000. Yun ho yung unang tanong. Pangalawang tanong na supported doon, in support of that question is, sa isa po ninyong ruling ng Second Division, Ancheta, People of the Philippines versus Ancheta, the court noted, you were part of the Second Division at doon po sa ruling, 86% of cases you audited from the Supreme Court Statistical Division. 86% natatalo, acquittal, dismissed, or reversed, kasi maraming procedural lapses ang police at ang prosecutors sa pag-handle ng evidence o sa pag-conduct ng buy-bust operation. What does this say about the slowness of justice? Drug cases po ito lahat. Yung sinasabi nating 86% ay malaki yung natatalo. So yung una po, ilan po ba? Kung due process pag-uusapan, covered po ba ng search warrant, warrant of arrest, itong mga naganap na mga insidente?
What period are we talking about? Those from July 1?
Opo, ma'am. July 1
July
to
1
present.
up to present. Passive naman po ang korte. We can only say that these have come within our jurisdiction when the cases are filed. My impression is that as of the moment, the courts are not yet involved. Yun ang impression ko. I can be wrong, but I have not heard from the lower courts whether those covered, the data that they are talking about, have led to really formal charges being filed.
But the arrest, have they been covered by warrants of arrest?
Saan pong nangyaring arrest?
Yung July 1 to August 22 po.
Wala, hindi ko po alam, pero parang wala ho ako naririnig na kasama yon. Hindi po ako nasasabihan kung may arrest warrant ako. Yon. Siguro kayo po sa media, mas kaya niyong tanungin ang pulis kung covered po yon.
I think that's, yun yung isang bagay na hindi sinasama sa reporting eh. Yung unang tanong, may warrant of arrest ba? Yung paghuli o pagpasok sa bahay, kung magsasearch, has not been included in the media reporting, which should have been standard, because then it gives the public a sense of what indeed is necessary to make all of these judicial and what actions follow from that. I have to confess that in all the monitoring of the media coverage, I have to say that the least scrutinized indeed are the courts. Why? Because it takes a special language. Mayroong mga salitang pag baguhan ka pa o kahit na matagal ka na doon, gagamitin mo sa coverage, hindi naman naiintindihan ng lahat ng tao. It's a very intimidating issue. And one of the advocacies na isinusulong namin sa Center for Media Freedom and Responsibility is a greater legal understanding of the issues indeed that do fall within the courts. Ang tanong ko siguro dito na may connection dito sa ating concern is in the discourse, madaling sabihin, due process, nakakagulo lang yan. Dito sa ating gustong gawin na linisin ang ating lipunan sa the plague of the drugs. Due process is a hindrance. And I wonder in your thinking and from where you sit, if indeed we can gather language that we can then say what due process is about. Why is it important and why is it necessary? And that without understanding of due process, kung hindi natin ito i-appreciate, wala nga tayong pupuntahan kung hindi dun sa justice na nakikilala, sampalan, patayan, dahil naman meron daw silang kasalanan. I think the challenge for the media and the challenge for the officers of the court is to make understandable bakit ito mahalaga.
I fully agree with you, Melinda. In fact, yun nga ang tinututukan namin ngayon kasi nakita ko na una-una sa Ingles. Ang lahat ng lengguwahe ng hudikatura sa Ingles. Kung naalala niyo po, nagtangka po ako na magsalita sa wikang Filipino doon sa RH Law. No? Mahirap pong gawin yung ginawa ko. Tapos yung mga kasamahan ko pong hindi taga Luzon, kundi taga Bisaya. Sabi, ang hirap naman yan. Next time, pag maglalabas ka ng ganyang opinion, magbigay ka ng English translation. So, in fact, ang isa ko pong nakikita na nakaka-intimidate sa court proceedings, the fact that witnesses are being asked questions in English. And there has to be a translator or interpreter in order to find a way to indigenize the question and then translate it back to English. So that sometimes our transcripts are really funny. Because you can there's always humor in mistranslation. So, unang-una po, isang kailangan natin gawin ay hanapan ng paraan na ang lengguwahe ng korte ay nasa isang lengguwaheng maintindihan ng mga tao. Pati, maari ko bang masabihin po yung mga nakikita niyong court proceedings sa TV, medyo hindi ho accurate yun. Hindi ho ganun ang nangyayari sa korte. Isipin lang ho natin, sa pinakapayak na paraan, ang isang proseso sa korte ay nagtatangkang marinig sa isang maayos na paraan ang panig, bawat panig, bago maghusga ang huwes ayon sa nasasaad na batayan ng batas. Kung kayo po ay nasa isang pamilya, isusumbong po kayo ng panganay na kinain ni bunso yung ulam na nakareserba para sa hapunan. Ano pong gagawin ni bunso? Tatayo siya at maninindigan. Hindi ko inubos yan. Ang nakita ko yung pusa, umakyat at nagbungkal sa kusina at tinangay yung galunggong. Hindi po ba? Isipin niyo ho, kung halimbawa tumindig si bunso at sinabing gusto ko magsalita, sinampal siya. O kaya kinadena siya, tinago sa kwarto. Wala kang karapatang magsabi ng iyong depensa. Isipin niyo po, murang-murang edad pa lang, may napakalaking sugat na sa kanyang kaluluwa pagkat yung hustisya hindi ibinigay sa kanya. At hindi po ba maraming mga alitan nga sa pamilya ay dahil paborito ni nanay o ni tatay ang isang anak kasi nung nagsusumbong si bunso o si panganay o sa gitna ay nakampihan ang isa. Hindi po ba kaya may sugat na ito ay dahil ang pakiramdam po ng mga tao ay kinulang ang hustisya. Gayon rin po ang korte. Kung ang ating mga huwes ay patas at marunong, mayroon siyang temperament na makikinig siya sa bawat panig. At sasabihin niya, totoo kaya ang sinasabi nitong bunso? O nakikita niyang mayroon pang isang piraso ng galunggong na nasa dulo ng kanyang bibig, kaya't hindi niya napapaniwalaan. Ibig sabihin po, ano po ang ebidensya? Unang-una ho, bigyan natin ng kalayaan ang ating mga mamamayan, ang ating mga kapatid po natin ang bawat Pilipino, na sabihin ang katotohanan ayon sa kanilang pananaw. Ang katotohanan naman po ay malalaman lamang natin sa pagkuha ng testimonya ng mga taong nakakita talaga sa kung ano ang nangyari. Hindi po iisang side lang, hindi naman po ang gobyerno lamang ang mayroong monopolya sa katotohanan. Kaya't kailangan ho talaga maintindihan na kung tayong mga bata pa, mga maliliit pa lang tayo, eh nagagalit na tayo pag walang hustisya sa ating pamamahay. Paano pa kaya kung sa larangan ng lipunan ay ganun din po ang mararanasan natin? Hindi po ba parang may pagninikil sa ating kaluluwa? Yun lang po ang makikita kung pinakapayak na paraan para sabihin yung due process na ito. Siyempre sa bahay po, mabilis yan. Yung hukom, si nanay, makikinig kagad at sasabihin, ikaw, papaluin kita, o ikaw, hindi ka ngayon makakakain ng hapunan kasi nakain mo na. Ganun po, si nanay ang magiging hukom. O kaya kung si tatay ang usually nag-adjudicate, hintayin nilang dumating si tatay mula sa trabaho. Ngunit syempre ho, sa hudikatura, merong kailangang formalidad. Ang juez po ay nandun sa mataas na upuan kasi kailangan po niyang ipakita na hindi po siya dikit masyado kasi pag bigla na lang pong makipag-high five siya doon sa isang akusado, sa isang mga partido, sasabihin ng kabila na kinampihan na niya. Kaya ho, hindi namin pwedeng pakita na malapit kami sa mga naglilitigate sa aming harapan. So, sana po maintindihan natin yon na in a more mature setting where rights and obligations of our people have been already assured by our Constitution, where the state is required to grant those rights so that people can feel free. People will cherish the presence of courts. I'm not saying that our judiciary is a very good one at this point. As you can see, the dramatic reform efforts that we have been pushing for is a direct result of our understanding that we have so many faults. That's why we're doing our best to repair whatever damage the institution has suffered from, and we are trying to strengthen the weakening knees of our judges and our court employees. The last thing we need is a public that will not support the judiciary.
Ma'am, pwede po ba mag-follow-up question? Doon sa question po nung kung warrants of arrest or search warrants, ewan ko kung gusto niyo pong mag-audit ng mga in-apply na mga warrants ng mga police na baka naman may covered o proper on compliance with due process. Ang follow-up doon ho, may kaso ho kayang na-file na. Kasi sabi niyo po kanina, ang problema is kulang ng prosecutor or hindi masinop yung trabaho. Meron nung dating prosecutor na sabi nagpa-plant daw ng evidence dati. Pero ewan ko lang kung dapat I'm sorry, I'm joking. But the point of my question is, okay, so may warrants, are there ways for the court to audit the drug war by sticking to rules that are properly within its own ambit? And I think the question is, exactly how will the court or the judiciary show its relevance? Because the way you've framed it is, you'd rather keep a balance between acting independently, the court, claimed courage versus your studied conviction that the truth is out there, that the rule of law is out there. Pero hindi ho ba ang balance ngayon while you keep the institutional integrity or independence of the courts, we may be throwing out the window rule of law and democracy and Bill of Rights because maybe the people want the court to speak out within its own ambit of influence.
First of all, the Constitution points to the Commission on Human Rights and we investigate those. We cannot act unless there is anything official that has been submitted to us. We don't even know the names. What I see on TV are just numbers. You have the names, we don't have the names. And then the police investigates. So we also are relying on them. Then the prosecutor files. So the courts cannot rely on what it sees in the media. The one that is required to make a stand or a position on the matter under the Constitution is the Commission on Human Rights. The Constitution requires us to be the last actor in this area. It is not because of shyness or reticence or lack of courage. It is because that is the constitutional design. Because we are required to be very fair while all the investigations are going on out there in the field. We are not field people. In fact, the media are the foremost field people right now in what is happening. So I cannot characterize whatever list you have because I really don't have information.
Pero ano po yung tipping point? Would there be a tipping point when the court would see that there is some role for it to play?
We act on complaints and petitions. Something is docketed with us, we act on what is docketed.
Can I bring up the problem that I thought as a layperson and completely no legal training, that perhaps also one of the things that the media can go into with your guidance perhaps is the classification of drug crimes or issues. I mean, the user and the possession of drugs is a completely separate, it's a completely separate problem, I think, which has, in fact, other people have said should not be fall simply as crime. And yet, when they do go into the courts, it's almost all the same kind of treatment, especially given a time when everyone seems to want to show that they are anti-drugs. Is this an area that perhaps the media can work with reporting on the courts and perhaps might lead to some kind of policy initiative on the part of the Supreme Court?
No, Mike wants to interject.
Yes, dagdag lang dito, no? Because I'm even wondering kasi about reforms of the drug laws, no? Because they're very harsh, no? When you compare it with many laws in other countries. No? People have often said if Nora Honor had been caught here in the Philippines for what she was caught in California, they would have thrown her in Bilibid and throw away the key. No? And only very small amounts are needed. And then if you're in the company of 3 or 4 people, that moves you into another classification. And as if that were not enough, in recent weeks, ang dami nating bagong terms dito, no? Drug user, drug pusher, and what really gets me, and drug suspects. And then there's this vague thing which involves hundreds of people, and this is drug personalities. No? And I asked the head of a police station, I said, ano ba itong drug personalities? Sabi niya, mga suspects. I said, pero iba yung, are you introducing a new term? And from the viewpoint of the judiciary, ano nga itong drug personalities? Can you haul a drug personality into jail nga? No? Being a person.
First, I think the government agency that has the statutory mandate for statistics gathering is the Philippine Statistics Authority, and the Philippine National Police, I know, is the one that also has to work with the PSA for the crime index. Now, I don't know to what extent the public can participate in it, but I know that the legal classifications of those involved in drugs are those that are found in the Dangerous Drugs Act. Other than those, the judiciary cannot by itself just take cognizance of these newly emerging terms. Many of these newly emerging terms might not have any legal significance at all, in the sense that it will not affect the amount of the degree of penalties they will be meted out, because we really have to strictly just adhere to what is provided in the Dangerous Drugs Act. Now, you are talking about terminologies morphing. I don't know, is it already for the judiciary to jump into the fray and discuss whether the classifications are correct or not? I will venture that when a case comes before the court, it will really just require what particular section of the Dangerous Drugs Act is being violated. And it will not involve itself with the classifications that are now emerging.
Ma'am, bila ho bang nanay, and I'm sure sa nagturo din po kayo, isa ho sa sinisilip namin yung impact nitong mga nangyayari ngayon sa mga bata. And you talked about maybe what are the questions about what are we telling our children? How are we educating them about these issues and the rule of law? But if you were to look at it, parang we've talked to some teachers and they're saying yung balitaan class ng mga bata ngayon sa araling panlipunan, puro ho drug war or drug killings ang na i-report. Ano po yung mai-advise nyo? How should we be explaining these things to our children? And I think media is also quite traumatized already. Reporters and photographers and cameramen are seeing bodies nearly every day. So ano po yung maikikwento nyo na parang pwede nating isipin, gawin, o pag-aralan para hindi naman tayo traumatized, but we turn this into a little more input on courage and understanding of democracy and rule of law.
You know, I wish I were as professionally proficient in this area as Mike. But as an educator myself and as a mother, you know, I've always believed that we should really contribute to our society in ways that are really uplifting and ennobling. And to that extent, even though there are many problems, there are many dark areas that I am confronted with simply because we are talking about cases of wrong and injuries. That's the staple of our readings. When you are talking about forming the minds of young people, I believe that every leader has to speak to the most noble aspirations of our people, to the good in our people. And that is my personal bias. I would rather help, encourage good to come out than encourage the darker side of the human nature. And I think even teachers instinctively would exercise that preference. Because the debate between expediency and the long-term effects on us as a people is a debate that must be engaged in. That's the most I can say on the matter.
So if I may move to perhaps another area of concern, you have given us a whole range of reforms, systemic reforms. I think we all have to admit in our country everything is political, judiciary is not exempt from politicization. In fact, in terms of public perception, everybody looks at Supreme Court decisions in terms of their appointment. So who appointed what and what to expect from that. And it's almost a built-in evaluation, which I think is terribly harmful for how we look at the High Court and its majesty and its ability to actually make these decisions. What would be your long-term response to moving this whole realm into what it is in many countries? That when the Supreme Court speaks, it may speak from its liberal bias or its conservative bias, but not from its political bias.
The president who appointed me had not been pleased with some of the decisions I took, positions I took. The president before him was not pleased with one position I took. The president before her also was not pleased with the position I took. So, I don't think I have pleased any president yet.
One. You're one out of.
I hope the JBC, to assure you, the regular members of the JBC are very professional. And right now, we are tightening the rules on independence. The new personal data sheet that we are distributing to be filled out by the applicants, this is the latest series, requires a disclosure of even potential conflicts of interest, the way that disclosures are being required by judicial commissions in New York and other jurisdictions. We require them to describe allied interests in the political, even in the political field. We're asking them to even disclose whether they are members of any political family or their relatives are members of political parties. We must understand that what is required of the 2,000 plus judges and justices in our ranks is really independence. Spines of steel, the ability to weather a storm, the ability to take even dark consequences of an adverse decision against a powerful individual. Nothing less than that will suffice. So I hope that I can tell you, and I can be given the chance to tell you about the brave stories of our judges, many of whom have stood up against our even very powerful warlords in their years. Note that the judiciary does not have a police force. We only contract out security guards to man the gates of our halls of justice. Our judges have handguns, some of them have handguns. We requested the PNP to issue licenses to them. We trained them in the use of their handguns. But in the face of a well-planned assassination attempt, there really is no insurance against that. So, what does the judiciary need to convey to the public? I believe with all my heart that there are enough men and women in the judiciary who are willing to sacrifice their very lives so that justice can be handed down in this country. There are enough people, even in the high places of the courts, who are willing to forego even personal ambitions for promotion, just so that they will be free to do what is right. What we need from the public is encouragement for those whose reputations remain unsullied. We do not want you to applaud the accomplishments of people who get promoted simply because of political connection. We wish that you will remind us that the sacrifice that is required for us is a sacrifice that we have taken fully aware of the consequences of living an independent life. It is not to anyone's material advantage versus private practice that we dedicate ourselves to a life in the judiciary. You must urge our judges to live simple lives. Do not admire them when they wear expensive jewelries. Show them that disapproval when you hear of luxury trips abroad. Require of them hard work, but support them when they are assailed. Show them that you have the courage to defend the judiciary in the same way that you have the courage to protect your families. If our judiciary musters enough courage, we will help bring this country to a new height of dignity, stability, and eventually economic progress. As you can see, all areas where we can reform, we are looking into everything that we can improve. This is much more than any past leadership has ever done. But you must be patient with us because you are talking about a 30,000 strong workforce. Values need to be inculcated, and they must be inculcated in a deep way. You must propagate stories of brave judges and court employees. And when we announce the disciplinary measures, they are really intended to have a chilling effect. But remember that when they are being shamed publicly, when Attorney Te announces their names, that is being done after a tedious process of investigation has been done, where they had every opportunity to comment on the complaints against them. We wish for a level of professional ostracism against those who have done wrong. How I wish on a personal level that we as a country learn how to ostracize and not show immediate sympathy to anyone who has been pronounced as having done wrong. Those that the court has pronounced as guilty of fraud, of larceny, of embezzlement, of plunder, why do we embrace them as if they are worthy of all emulation? Why? That keeps on bothering me, really. Why we keep on shooting ourselves in the foot just when the court has already mustered the courage to pronounce guilt, then the people embrace the guilty. I think we really have to examine ourselves and our values as a nation to already show social disapprobation of those who have wronged our society.
Can I ask, if we move the story forward for all the reforms that you have initiated, you will have until 2030 to implement them. But also, during the term of President Duterte, he will have the opportunity to appoint 11, maybe 12 associate justices of the Supreme Court and many more justices, Court of Appeals, Sandigan Bayan, etc. What do you wish should happen? I mean, in terms of the quality, competence, character of justices that we need to move forward your reforms, and what do you think could be avoided?
I trust the President's judgment on this matter. I give him every benefit of the doubt. He has already said that he is strongly against the corrupt. He is strongly against the laggards. So in this way, the same standard is being applied by the JBC in shortlisting names. And I hope that he sees our effort in making sure that those with unsullied reputations, those who can work very, very, very hard at resolving our cases, those who can really contribute to justice, are only the ones that he will ever consider.
You're confident that the best results will come?
I believe what he is saying about his desire to really improve the country, and that he wishes only honest people to be in government. Let's all allow that to be demonstrated.
More of a commentary. I'm very struck by, and I totally support you in giving more, making people more visible, the heroes in our judiciary. But I also see a problem here, and this is in relation to our law schools, lawyers-to-be. We want them to see these heroes in the judiciary, but they also have other idols there, and these are the ones who enter the private sector and do very well. No? So they're not corrupt, but they get very rich, they have very lavish lifestyles, and I know it's very difficult to convince our young lawyers to enter public service and to keep clean nga. No? So this is really more of a commentary. And maybe, kaya pumapasok din ito sa image ng, yung image ng abogado at image ng judiciary overlap, whether we like it or not. No? And so maybe the chance to prove ourselves in terms of the judiciary, that idea of independence and integrity is so difficult to grasp because we live in a patronage society. It's presumed na pumasok ka dito at na-appoint ka dahil nga sa mga connections. No? I'm very hopeful for the reforms you're introducing, and perhaps that's our only card left right now if we have a system that works well. No? I would like to say also na mahalaga ang small claims court, ang family court, because these are the closest interfaces with people's daily lives. They will judge the judiciary based on their experiences at that level. Maybe quick example lang, sa annulment lang. No? I was just talking with the UP professor, her annulment proceedings have been languishing. This is a UP professor, umabot na ng point, I know she said this half in jest, sabi niya, pupunta na lang ako sa Quiapo at magsindi ng itim na kandila. No? This is against her husband nga, because she doesn't have any hope that the annulment will ever come. But this is very typical. No? So if we're, even Pope Francis has spoken of the need for compassion in hindi annulment kasi sa simbahan, di ba? Or annulment din. Annulment ang tawag, no, sa simbahan. What's our term? No, I just want to be. I'm trying to make sure we have the right term there. Anyway, Pope Francis has said that the procedures are also so unfair to the poor. They have to spend for transportation. They have to spend for a canonical lawyer. And I thought that something similar is happening here in the Philippines. And people will talk with neighbors and say, ang bagal-bagal ng mga procedures dito. No? But again, as I said, that's why it's so important at that small claims court, family courts, that we get a lot done. No? I was surprised to see that one of the Supreme Court decisions was around child custody in a divorce granted by the Sharia. No? I said I didn't know that the Supreme Court actually enters such domestic matters, but that is what affects people's lives. And I hope when people realize that, they will understand the need for independence, integrity, and due process.
Two-pronged yung question mo, no? Yung isa yung image ng abogado na luxurious ang living pero nasa private practice. I am so proud to have professors of law and full-time practitioners giving up their private practice, their lucrative income to join me in the judiciary, either as judges or as Supreme Court officials. And more of our young people are entering government service. UP people are entering not only the Supreme Court as court attorneys, but also the Office of the Solicitor General. We need more of our idealistic people to join government service. The pay is actually competitive at the first few years. So in order to debunk the myth that you will be poor if you become a government lawyer, the pay is now competitive. But of course, after a number of years, it is no longer competitive when you're going to compare your life with the life of your partner in a major law firm. Then there is a ceiling in serving government. There is an income ceiling. Now, my appeal to the lawyers is this. You are already blessed, privileged, especially if you had been educated in UP, where your tuition basically amounts to nothing compared to what is being paid in private law schools. So much social resources have been built in order that you can join a privileged profession, a profession that is looked at by society both with fear and with envy. Do not waste your time trying to amass wealth which you cannot enjoy for a lifetime anyway. Who knows what's going to happen to all the money you're going to leave behind? It is not your duty to ensure, and you cannot actually ensure, the prosperity of future generations. Your only duty to yourself and to God is to make sure that you do what is right. Act according to your conscience, serve your fellow man, love your country. What is required of you, O man, if it is not to act justly, love mercy, and walk humbly before your God? Remember, the lawyers, and I'm talking to the lawyers here, I have seen the most successful lawyers in the country. I have seen their wealth. I have seen how they flaunt it, how they enjoyed it, and at the end of the day, it all amounts to the same thing. All of them die, and all of us will die. The only question that matters is what happens to the afterlife. Did you live in such a way that the afterlife mattered? Did you think where you would be at the end? If you did, then you lived for a long-term purpose. If you did not, then your life had been wasted. So I hearken a call to my brothers in the robe and then my brothers in the profession. Our profession is supposed to be a noble profession, an enabling profession, a profession where we can talk of the highest virtues of man. Do not bring it down. We are in our best, exerting our best efforts so that people can look up to us again. Join me. Join the judiciary.
Yeah.
Having battery problems. That actually answers a question that was posed on video earlier as to what advice you would give new lawyers, whether they should first go to government or first go to private practice, and what would you would advise. But we'd like to end this round with last video, and it's very good, ma'am, that you ended with a call to lawyers because this is a question about the bar exams. Can we have a question from Justine Kyle Del Carmen from Colegio de San Juan de Letran, Manila?
Hello po, yung tanong ko po, ano po yung mga advices niyo sa mga nag-fail sa bar exams? Thank you.
I have actually expressed my lament to the Philippine Association of Law Schools. This is the association composed of all the law deans in the country. I tell them, it is your duty to ensure that those who fail the bar exams have a life after failing the bar exams. These are actually so much resources are being put forth by families selling carabaos and lands and other possessions just so that their son or daughter could finish law school. Do not tell me that we are not accountable for the lives of these people, whether they are going to be future paralegals, whether you are going to propose that they have limited license to perform parts of lawyering short of appearing before the regional trial courts. Go and try to exercise your mind so that you can create a way out for them. It is so expensive to put anyone through law school. We have a social duty to make sure that those resources are not wasted. So if you fail the bar exam, I am not automatically advising anyone to retake it. That is not fair advice. Before I can advise anyone to retake it, you have to walk through with him or her the expenses of reviewing again for another year and putting one's life on hold. What is most important is that we provide options for those who do not make it. Do we, in fact, and I have been in discussions already, do we give them limited authority to perform what? What kind of privileges will they be able to enjoy if they did not make the 75% cutoff score, but they still have a score of 65? Can we gradate those capabilities? Because we are responsible for every person that we get in contact with. We get them under our wings, educate them through our law schools. Surely you have a duty to ensure that he is better off after having attended your school so after having attended your school. So I think it needs a lot of thinking on our parts. Do we allow these those who did not make the grade then we authorize them to prepare contracts, to prepare affidavits, to appear for what kinds of litigation? Do we authorize them to do corporate lawyering? What kind of skill sets are required for a particular set of lawyering? So that would be how I would answer it.
The battery is gone, so I think we've come to the end of a very interesting 2.5 hours this afternoon for the 4th edition of the CJ Meets the Press. And we'd like to thank our second panel, Melinda Quintos de Jesus, Dr. Mike Tan, Malu Mangahas, and our first panel, Erin, Vince, Buena, Lloyd, Ina, Cecil, Johnson, and Virgil. And of course, all the technical crew who have been here since last night, making sure that we have everything set up. And I'd like to thank all of you for joining us again this year for CJ Meets the Press. Maybe with the permission of the Chief Justice, see you next year in August. Thank you very much, Chief Justice. Salamat po. Thank you very much. Have some photo opportunities.